So let's kick this off. Welcome to our Supreme Court View from the Press Gallery. I'm Christina Jackson. I'm the Executive Director of Washington Council of Lawyers, and we are the Public Interest Bar Association for the District of Columbia. Our mission is to strive to ensure our legal system treats everyone fairly, regardless of money, position, or power. One of the most important roles we play in our community is bringing together public interest-minded law students and lawyers from small and big firms, in-house legal departments, nonprofits, and government agencies. And together, we work to advance access to justice. We invite you to join our vibrant public interest community, and you'll see how in the chat in just a couple minutes. I also hope you will check out our upcoming events, Fellowships 101, and our Best Practices in Pro Bono series. You can register on our website, and a direct link will be in the chat shortly. Today, I'm excited for the journalists who cover the Supreme Court to join us to talk about the inner workings of the recently concluded term. You can follow our conversation on Twitter using the hashtag SCOTUSPress. Today's program will be recorded for those who registered and either weren't able to attend or want to go back and watch it again, which certainly might be me. Our moderator today is Art Spitzer. He's senior counsel at the ACLU of the District of Columbia. He's been with the ACLU since 1980 and served as the legal director until April of 2020. Over the years, Art has worked on cases in a variety of areas. Just a few are freedom of speech and religion, police misconduct, due process, prisoners' rights, discrimination, and much more. So topics that are in the headlines right this minute. The list of matters that Art has worked on and the clients that he has represented is long. And so I will just highlight a couple. First, in the Supreme Court, Art successfully argued Aukie versus Oklahoma, which ruled that poor criminal defendants are entitled to free expert witnesses when needed for their defense, just as they are entitled to free lawyers. And secondly, Art and a colleague, Marcia Lowry, pursued LaShawn A. versus Bowser, which settled last year, but was filed in 1989. This is a class action lawsuit that transformed the DC foster care system from a dysfunctional mess to what the judge called a national model. And that is the power of a relentless lawyer like Art. Art came to the practice of law via Brooklyn, where he was born, and Queens, where he grew up, so a strong New Yorker, Cornell University, and then Yale Law School. I am pleased to welcome Art and our panelists to the screen.
Thank you, Christina. Thanks for the flattery, and welcome everyone to this 34th annual View from the Press Gallery program. Our thanks to the Washington Council of Lawyers for sponsoring the panel again this year, and thanks to all of you for attending. I think Christina mentioned, but I'll repeat it, that the webinar is being recorded. And so if you don't want your face to show up for anyone in the world to see, you might want to turn off your camera. On the other hand, I invite my panelists to turn on their cameras so everybody can see them. And let me introduce them in order of how long they've been covering the court. David Savage, who you can't yet see, but we'll see in a moment, has been with the Los Angeles Times since 1981 and covering the Supreme Court since 1986. He's the author of the latest edition of the Guide to the U.S. Supreme Court, published by CQ Press. He has degrees from UNC Chapel Hill, which is a litigant in one of the cases we'll be mentioning today, and Northwestern University. Mark Sherman has covered the Supreme Court for the Associated Press since 2006. In more than 35 years as a reporter, Mark has covered national politics, Southern politics, healthcare, and the Justice Department. He previously worked for the Atlanta Journal-Constitution before coming to the AP. Adam Liptak took over the New York Times Supreme Court beat 12 years ago, but he has a long history with the Times, which he first joined as a copy boy in 1984 after graduating from college. He went to law school and returned to the Times as a lawyer before becoming a journalist. um, as I say, about 12 years, became a journalist longer ago than 12 years, but has been covering the court for about a dozen years. Amy Howe publishes Howe on the Court, a blog that covers the Supreme Court and the judiciary in mostly plain English. She's also an independent contractor and a reporter for SCOTUS blog, where she used to be the editor. Before turning to full-time blogging, she was counsel in more than 24 merits cases at the Supreme Court and argued 2 cases there, and has taught Supreme Court litigation at Stanford and Harvard. Kimberly Atkins Storr is senior opinion writer and columnist at the Boston Globe, and also lead columnist for The Emancipator, a publication that reimagines 19th century abolitionist newspapers to reframe the current national conversation on racial justice. And I hope we're going to learn more about that during this conversation, since that's all I know about it. Previously, Kim was the Boston Herald's Washington bureau chief and covered the Supreme Court for Massachusetts Lawyers Weekly and its many sister weekly publications around the country. Before becoming a journalist, Kim was a litigator in Boston. Her law degree is from Boston University. Her journalism degrees are from Boston University and Columbia. This is not going to be a panel analyzing the Supreme Court decisions the way so many other end-of-term panels are, although we'll talk about those decisions some. But our plan is really to talk more about the court as an institution and as a collection of individuals, and about covering the court as journalists. We will all try to keep an eye on the Q&A. So if you have questions, feel free to post them anytime, and we'll try to jump on them if they're relevant to what we're talking about, or maybe save them for the end. But let me start by saying everyone agrees that this was a momentous term at the court. What about it was most notable or surprising to you? And I'll start by asking David, who's been at this longest. David?
Well, it is true, as you said, Art. I go way back in the speed. I started in the summer of 1986. I was thinking the other day, that was the summer that Rehnquist became Chief Justice. Antonin Scalia joined the court. And when I got back to Washington, I remember the talk was, you know, Roe versus Wade is in danger now. The separation of church and state is in danger. Rehnquist was not in favor of separation of church and state. You know, Scalia and Rehnquist, their first term, voted in favor to uphold a Louisiana law that required equal time for creationism in schools, if you remember that era. And everybody said affirmative action is now in real danger. There were a whole series of set-aside cases. So I thought, you know, in one sense, it's the conservative legal agenda has been almost the same for about 40 years, since the Reagan era. And what was so notable, and I think to much of the country surprising about this term, was that suddenly it all, you know, came to pass. The conservatives sort of swept all the big cases: abortion, guns, religion, regulation. There was a 6-3 split across the board. The liberals essentially won no big cases. And so this is a new conservative court that's very confident and bold and willing to do things like overturning Roe versus Wade, like the first time they get a shot at it. And so we're in a sort of a new, interesting world. So yes, extremely notable, and but not too, in one sense, not too surprising.
Mark, you want to go second?
Well, I would say, just following on from what David said, the one sort of surprising thing to me was that although the Chief Justice was certainly part of that conservative majority almost always, it was, to me, surprising to see him unable to slow the train at all, it seemed like, whether we're talking about overturning Roe or in a case the court's going to hear next time, allowing stopping the redrawing of congressional districts in Alabama, where the court seemed to be moving, in Roberts' view, almost faster than it needed to or should be. And yet he couldn't attract any support from the other conservatives on the court to sort of take a more measured approach.
Kim, you're shaking your head. What
Yeah,
was notable or
I agree
surprising?
with, yeah, I agree with that. All of those things are surprising. One thing that's sort of been surprising to me as well. I mean, it's all of a piece, right? To me, there are a lot of things that I used to say about the court, which is even though there are ideological differences, I thought that the public misunderstood um, the difference between ideology and political, and a lot of folks in the public thought that there was a political bent, a political agenda on the court. And I would say, well, no, there are ideological differences that sort of align with the party that nominates the justice, but it's very different from Congress. I think that's a harder case to make now. I think we are seeing the clear impact of politics on the court and the politics within the court making itself known in a way that I've never seen before in my time covering the court. So that certainly is an interesting thing. And I think in connection with that is the increased emergency docket, so-called shadow docket. I thought, again, well, this is something that's done in emergency situations, and it doesn't really, it's not really an agenda setting thing. It's not really meant to supplant merits cases. And after a while, it's like, well, no, I can't say that anymore either. Just the use of that, particularly in the COVID restriction cases, that really was a foreboding about where the court would be on issues like religious freedom and separation of church and state. So it's just the court is just a different animal than it used to be. And the leak is a part of that as well. So that was the biggest surprise to me.
Adam?
So when I started covering the court in 2008, and this was true through almost all of American history, you couldn't tell for sure how someone was going to vote by looking at the president who appointed the justice. So Souter and Stevens, both Republican appointees, were still on the court in 2008 when I started covering the court. And Kennedy, of course, was a Republican appointee, leaned right, but could surprise you. And even the Chief Justice, when he was briefly the median justice, didn't always vote in a conservative direction. But it turns out that Donald Trump cracked the code and was capable of finding 3 justices who would deliver consistently, categorically, relentlessly conservative decisions. And the lasting legacy of Donald Trump is 3 members of what is now a 6-justice supermajority that, as Justice Sotomayor wrote, is restless and certainly seems ambitious and impatient and raring to go, and has none of those impulses of the Republican appointees that I mentioned before.
Amy?
For me, I'm not going to talk so much about what was surprising as what sort of stood out to me throughout the term. And that was a sense that unlike any other time, any other term in the 20 years or so that SCOTUS blog has been in existence, that I was watching history in the making. This was a weird term in the sense that the justices were back in the courtroom after a term plus operating fully remotely. And they were back with this hybrid setup, which we can talk about some more at some point, in which only the reporters with permanent press credentials, clerks and staff and lawyers were in the courtroom. And so I felt, I guess, almost a sense of responsibility to show up and watch what was going on, because the live audio is great, but I don't think there's any substitute for the real thing. And to see sort of the rancor, to see the grim look on Elena Kagan's face sometimes when she came out from behind the curtain, there's just a sense of history that I hadn't felt before.
Well, speaking of COVID, let's talk about how COVID continued to influence the court this term, and particularly how it influenced your ability to cover the court. And Amy, since you led us into that area, why don't I ask you first?
Sure. I mean, I really appreciated being back in the courtroom. As I said, for me, there's no substitute to being there. I tried to go to as many arguments as I could, even when I wasn't covering the specific cases, to see the dynamics among the justices. And, COVID was always present in the sense that for most of it, we were masked We had to test before we showed up at the court. We were seated in a different part of the courtroom. Usually we sit crammed into the press section on one side of the courtroom. But because of social distancing and because there were very few other people in the courtroom, we could spread out. And so we had literally a different view of the courtroom than we normally had. And the justices shifted to this hybrid argument format as well, in which they had a regular stretch in which anyone could ask questions, and then they took turns asking questions. The upshot of that was to make the oral arguments extremely long in some circumstances. So in some ways it didn't really change the way that I covered the court. The big difference to me was that the justices did not release opinions from the bench. There was really no reason why they couldn't have, in my opinion. But even when they were in session from October through late April, hearing oral arguments in person, they opted to release opinions normally on Thursday mornings when they would not have been in session. I think they just wanted to avoid the live audio coverage of the opinions or having to consider whether or not to do that.
Yeah, and that's a real shame. I mean, I remember the very first day I covered the court as a reporter back in 2007, and it was on the day that the Gonzalez v. Carhart ruling came out, and that was the court upholding the so-called federal partial birth abortion ban. And Ruth Bader Ginsburg gave a bench dissent, which was the first she'd given in a long time, but the first of many that she would give during that era. That was just really a powerful, powerful thing. And to witness that, and among the things she said is the only thing that's changed since Casey and now is the makeup of the court, which is obviously a theme that would recur. And it was just an amazing moment. Doing that brought such attention to it, and that's not happening now. So I think that is actually blunting the force of the dissenters' ability to really communicate their message and speak for the ages in cases that are monumentously important. So that's a huge, huge difference there.
Adam, you've been nodding your head. How has COVID changed your ability to cover the court?
Well, so I got 2 points. One is it does allow you, because they have live audio, which we've gotten quite used to, but is a radical innovation. The idea that the Supreme Court would have live audio, if you asked me 5 years ago, I would say that's impossible. They very reluctantly used to release audio at the end of the week. Now you have live audio, which gives you the option of not going to the courtroom. I agree with Amy completely that going to the courtroom gives you a substantial insight into the dynamics of the court to look at them on the bench as each of them is talking. But you could also sit at your desk and listen live and look at Twitter and get distracted, but also deal with your editors. And so that gives you a choice about which way to go. On the release of, on announcement of decisions from the bench, that actually does seem to be a real sea change. Now, that audio didn't used to be released until at the beginning of the next term. And they've always been wary of letting the public think that that is gospel, that the writing justice's summary, and they obviously don't read the opinion. They summarize it often colloquially, sometimes ad-libbing stuff. And you can look across the bench and look at some justice going, did I agree to that? Because it's a characterization of the opinion. And I think that makes them wary of giving people immediate access to the audio. Now, there's 2 solutions to that. One is to get everyone to sign on what you're going to say. The other is to release it, at least in the courtroom, allow people in the courtroom to hear it, and maybe defer release of the audio. But the current system, which takes away from what I think has been a tradition at the Supreme Court since forever, of announcements of decisions from the bench, to withdraw that, even as the court is closed to the public because of the pandemic, and even as it's circled by a security fence because of the aftermath of the leak and so on, to withdraw this element of public access to the court, of issuing decisions from the bench, is a big step.
Mark, did you?
I would agree with that. I think, I mean, it made the whole decision release kind of bloodless in a way. And it was the relatively few moments of drama that you get at the Supreme Court, and it's only sometimes once a term or a couple of times a term, is this, is this moment when Justice finishes reading a summary of his majority or her majority, and then the dissenter starts in. And, there's sometimes, again, not often, but the reactions on the bench are sometimes visible. And, it makes the story, I mean, the decision is compelling, but it makes the story even more compelling. The other thing I would say, although I think it's great that more people now have access to audio, one of the dilemmas for a reporter is that, in a way, the more important the case is, the more likely you are to sit at your desk and report on it rather than to be in the courtroom. Because, as Adam said, you have to deal with your editor. In the case of a wire service, that next version of the story has to get out. So I think that's sort of lamentable in a way.
And so did you sit at your desk for most of the arguments this term?
Well, so the Associated Press has two full-time Supreme Court reporters. So we made sure, I think for almost every argument, I think with the exception of when Justice Jackson was going through confirmation, that one of us was in the courtroom.
And another thing that happens in normal times is that there's a press room on the ground floor of the court, and all the reporters, those who are in the courtroom hearing arguments or decisions, plus some who stayed down in the press room, would be there as soon as the court adjourned, and you could talk to each other as you were starting to write your stories. Did that happen at all this year? And did you miss it? And did it affect how you covered things, David?
Well, I would say that the thing that I miss most about the unfortunate result of the pandemic is not seeing my colleagues at the court. Besides being a good group of people, I also learned a lot just talking with them about cases or things that are going on. So yes, I miss that. But as somebody said, Adam or Mark may have said, if you're actually writing a story about a big argument, I must say it's a lot easier for me to do it at home, listening to the audio in front of my computer and typing notes. Because if you're in the court, I did that a lot of years, we all did a lot of years, you sit there with a little notepad, listen to an hour and a half argument. I've got notes that I can barely read. We walk downstairs and somebody says, well, that sounds like a close call. They seem really divided. And then I sit in front of my machine and say, okay, what do I write for this argument? And it takes quite a bit of time to piece together an argument based on my bad notes and my recollection. Where if I'm sitting at home and there's a big argument, I can listen, take notes, arrange something. And when the argument is over, in fairly short order, I can file a story. So it's more efficient and effective for me, even though, if I had my choice, I would rather be there in the courtroom and I'd rather talk to my colleagues. But the honest to God truth is that I think I actually do better and certainly faster argument stories doing them by listening to the audio and typing at home.
Yeah, it's interesting. All I'll say quickly is different reporters have different takes on that post-argument chat theory. For me personally, I didn't like it because I needed to trust my gut. And when I was coming out of an oral argument, I sort of had an idea of what I was going to write. And sometimes for me, when I would hear these very smart people on the screen talking about something and their read was a little different, that would freak me out. And then I would second guess my gut. So what I did when I covered the court is I didn't even stay in the press room. I would just grab my stuff and leave and go to my office and go write my story over there, just so that I could, be alone with my thoughts. My husband, who, funny story, I met in the press room of the Supreme Court. He's the opposite. Like, he really, really liked having that. What is that Sotomayor said? And that was that responding directly to Gorsuch? He liked having that, and he really missed that in the early parts of the pandemic before folks went back. So I think it depends on your style.
Most of you covered other beats before you came to this one. How is covering the court different? How is it the same, I guess, and how is it different from covering any other beat? Mark, you used to do a lot of other things.
Well, with the leak and with the increased use of the emergency docket, the shadow docket, in truth, the court is becoming more and more like other beats I've covered. You used to be, seemed to me, we sort of led a fairly leisurely life compared to other reporters, people who covered Congress and the White House seemed to be always on duty no matter what, and we had the morning arguments and the afternoons to write our story, and our evenings were pretty much our own. And these days, that's just not the case.
Yeah, I mean, there was a period of time when I was the bureau chief at the Herald. I covered the court and Congress and White. I was the Washington reporter for the paper, so I was covering different things simultaneously. And I loved the days that I went to the court because it was like that was like normal life. You never knew what Congress or any other political news in DC was going to throw at you, particularly over the past 5 or 6 years. But when you get to the court, there's going to be an argument, it's going to start at 10, you're going to get your assigned seat, you're going to get to write the story. It seemed like until this year, an institution that was so reliable in its rigidity that it made it a lot easier as a reporter. It felt like a little break or a reprieve. Again, this year was very different for a lot of reasons, but I loved going to the court on those days, just in part because I could think about something. I had an hour to sit there or more during oral arguments and think about a legal issue, something substantive, and really dive into it and write about how that would impact the American people in a way that politics sort of felt a lot less substantive often.
So you moved from reporting on the court to doing a lot of opinionating about the court and its decisions. How did that change how you work when you write an editorial that relates to a case? Do you still read the briefs? How has it changed your whole perspective on the court, if at all?
Yeah, the experience. I mean, one of the reasons that I was hired on the editorial board at the Globe is because of my experience covering the court, because they recognized the importance of having someone who understood how the court works in writing these editorials. The reporting is the same. You still listen to the arguments, you still read the briefing, you still read the opinion, and really dissect it. It's the difference is just in the call. There's a call to action of some sort at the end of it. And so in a lot of ways, it's the same, but it certainly is great to have that experience as a reporter, having sat in that courtroom, understanding the dynamics, to be able to write more thoughtful editorials and columns about what the court is doing. So they're not that dissimilar, but yeah, it's an important time. And I think you're seeing more news publications look for people with Supreme Court to focus on the Supreme Court or with Supreme Court experience because of what's happening at the court.
And maybe this is a good opportunity to tell us a little bit about The Emancipator, which I confess I don't know anything about. Do you write about Supreme Court stuff for The Emancipator?
Yes.
And how is that different from newspapers we all know?
Yeah, I actually have a piece in The Emancipator today about the separation of church and state and the recent decisions by the court. So The Emancipator is an independent journalism project that is a joint project by Globe Opinion and Boston University's Center for Anti-Racist Research. And it was born out of a conversation between my former editor, Veena Venkatraman, and Dr. Ibram Kendi about abolitionist era newspapers and what they did and how there is room there's a need in today's media landscape to have that same sort of call to action, that solutions-focused, action-focused journalism, given the racial justice issues that we were experiencing in real time, to have that focus. And so that's what it does. And so I've looked at everything from the way the Dobbs decision will particularly impact women of color and LGBTQ folks to, like today, asking just whose freedom of religion is really being most protected by the court, and is it equal? And it appears not to be so.
Interesting. Well, let's move back to those of you who are covering the court on a daily basis. One thing that hasn't changed is that you have to digest opinions that may be quite long and quite complicated, decisions that may be splintered, although these days it's mostly 6-3, and get news out pretty quickly. And I wonder how you managed to do that. Mark, how long after an opinion arrives on your desktop do you have to get a story on the wire, if you still use that phrase?
We still use that phrase. Well, it obviously depends on the subject, but the abortion opinion, we had a flash on the wire, which is the highest priority we have within, under a minute of the decision being issued. And, it would sort of be journalistic malpractice if we all weren't ready for it. The biggest case of the term, we had months and months to prepare. We had the additional benefit of a draft opinion that sure looked a lot like what ended up being the majority opinion for the court. So it was very easy in one sense to be ready, with that version of the story, as well as, the version where the court didn't quite go so far, and even the versions that seemed totally, beyond the realm of possibility, but maybe not totally, that the court would do something else. So that's what we do. I think I'm speaking for everyone. In a case like that, we spend the months between the argument and decision getting ready so that we can tell the world really quickly. We had a 1,200 word story out within about 3 minutes of the decision. Now, that was not a story that was chock full of things from the decision or from the dissents, just what the court had decided, that Roe had been overturned, and who was who was where, and then a lot of background, and then spent the rest of the day filling that out.
How many different versions of the story, if you remember, did you manage to put out that day?
Oh, I think, every time we change something in the story, it's considered a different version. There are probably a couple of dozen.
Wow. And was that similar for you, for example, Adam? Did you get a story up fast and then many later versions?
I think I probably filed within 5 minutes. So I could not compete with Mark Sherman, but I try to work fast. And I did pause long enough to do a word search for overruled. That was good to know. And then I did pause for a minute on the Chief Justice's concurrence so that the reader could make sense of, what part of it was 6-3, what part of it was 5-4. But we got it up very quickly. And then, like Mark, most of what we published was in journalistic jargon, B matter, background material. And then in the course of the day, I probably did half a dozen versions of the story.
And I wonder, did anybody use one of these computer programs that allows you to compare two documents and see how they changed, to see what changed from the February draft to the June opinion, if anything? I guess not.
Well, I didn't, but we did as an organization. We had someone charged with doing that, and we put out a comparison of the two documents.
And were there any significant changes? I didn't do that.
Substantively, I would say, very few. There were a couple of, there was one point, I'm forgetting the exact thing, but in the draft, I think Alito was talking about how many states where abortion was legal, and it said 0, none, or something like that. And I think that sort of rhetorical flourish was excised in the final opinion, but I can't think of many other important changes.
Well, and he did, of course, respond to the dissent and the concurrence. So the main part of it didn't change, but there was some more dialogue with his colleagues.
Can I ask a question?
Yeah.
How many versions, for the news folks, how many leads did you write? Like, how did you have ready to go for that story, or on average, how many you have for other stories? I'm amazed at, or maybe only my husband does that, but how many leads did you have ready to go?
I think I had 3 for the Dobbs case. The really challenging one for me was the Remain in Mexico case, in which it was like a choose your own adventure. Are they going to decide that they didn't have the jurisdiction to hear the case? Are they going to decide that it was, it was a rule, but the US had waived it? I mean, there were just all of these different ways that it could go. So for me, that was the most challenging one to prepare for.
Yeah, EPA was challenging too, I bet.
Well, EPA, I struggled with EPA from the get-go because it was just such a technical case to try to explain it to someone in a plain English way. It was next to impossible for me at least.
And so Amy, how many, if you remember, how many different leads did you have for some of these stories? What's like the maximum?
Well, like, we too do not try to compete with the AP or Bloomberg in terms of speed. So, but I feel like I had 5 or 6 different ways that the Remain in Mexico case could have gone. For something, for the Dobbs case, I had a story that was ready to go. For SCOTUS blog, we're live blogging when opinions are released. So I'm not trying to get the story up immediately because I have to wait and see what else the court is going to give us. But I had a version that was ready for my editor to fill in the very basic details and go. And just a tiny nitpicky complaint about the court's failure to release opinions in the courtroom. We're also not, like, it's not just that they don't release them in the courtroom, we're not in the press room where we normally would get paper copies of the opinion. And for some reason, when you've got complicated decisions, it's much easier for me to look at a paper booklet and try to figure out what's going on than it is to be scrolling on my computer.
I wonder if most people watching share that.
Yeah, it certainly would be easier for me, but I figure that's because I'm so old.
Well, let me say, Art, I think this is one of the really interesting changes of the past 10 years. We all have to adapt to it. There really is, I sense it all the time. It's a lot of pressure to file very quickly. That's why we spend a lot of time preparing these stories. And in many decisions, there's 2 or 3 possibilities. You've got to look at the decision very quickly, look at the syllabus, count the votes. And even though I'm ready to file one of those, I'm still thinking, am I sure about this? Is this? And on the plus side, so there are a lot of big cases this term, and on the plus side, the results were almost all predictable. In other words, it came out pretty much like we thought it would. But there was one in the middle of the year. Do you remember one of the Texas abortion cases that they heard arguments on the question of whether anyone could sue? And the opinion comes out, we're all ready to go waiting for it. And it was strangely an 8-to-1 vote, it appeared initially, to allow lawsuits against a variety of people, including some state licensing officials. That actually turned out to be a misleading. In other words, this was one of the really struggle. You put up the story and you look at the opinion and it doesn't make sense. After about an hour or so, I can't remember, I ended up saying this is basically a 5-4 loss for the abortion rights people. But on first glance, it looked like an 8-1 victory. That is that they had opened the door. So that's when it really becomes an interesting challenge, because you feel like you've got to respond very quickly, put up a story, say, what did the court rule? What's it mean? And you look at it and it's very unclear. And so fortunately that will only happen once this term that I'm aware of, where you looked at the opinion and it didn't quite make sense. This end of the court term turned out to be very predictable. And I think, as Adam said, like on the abortion case, the only thing that I was most interested in or most concerned about is what does the Chief Justice do? Does he join the majority or does he write separately and not join the majority? And it was, of course, the latter. You could figure that quickly. But it is true, I can't think of a term ever where the very biggest decision of the term, there's been a leaked draft copy of the opinion 2 months in advance. We've never had that happen before. But for the most part, they were very predictable, which actually to some degree worked to our benefit.
So Amy, I think you mentioned earlier that the structure of arguments was different this year and last year from what it used to be, with justices taking turns and not interrupting each other so much, and arguments going often past their allotted hour. Is that an improvement? Do the justices like it better? Do the lawyers like it better? Do you think they might continue that even when things are back to normal?
I think clearly the justices like it. I think they liked, after the term spent remotely, the idea that Justice Clarence Thomas was participating in quite in basically all of the arguments after periods of up to, I think, 10 years in which he did not ask questions. And so clearly they thought it was something worth retaining. I'll be curious to see, after they've used it for a full term in the courtroom, whether they continue with it. My guess is that they will. I would have expected that lawyers would have also preferred it, because it was somewhat less of a hot bench. And then you had the opportunity at the end to really feel like you were addressing all of the justices' questions, because they'd ask additional questions. On the other hand, I talked to experienced Supreme Court lawyers who didn't really like the setup that much. They liked the full-time hot bench and seeing the justices interact with each other more. They're being able to figure out at the beginning what the justices' concerns were. So, who knows?
It's funny. I had the sense from talking to probably some of those same lawyers that they're sort of like, almost like professional egos preferred the hot bench, but it was a lot easier for them. I've heard several say it's a lot easier to deal with arguments where that the next question is coming from this justice, and then a couple of questions later, it's going to shift to that justice. So you don't have to worry. You don't have to worry about being under attack the whole time, because, as it moves from justice to justice, the tenor is going to change.
You don't have to do that move, which is part of Supreme Court advocacy, of taking a hostile question and pivoting and inviting someone else to jump in. There's a kind of rote quality to it. I wonder also whether there's not some strategic behavior on the part of the justices, particularly the junior justices, of saving their best questions for last, when there's no opportunity for others to respond to them.
Huh.
Although we did see a couple of arguments where, a justice said, "Chief, do you mind? I have one more." And
yeah, so I think Justice Kagan, for instance, would like to leverage her junior position vis-a-vis Justice Alito, but it doesn't always work, because Alito will then ask a question out of turn.
So this was Justice Barrett's first full term on the court. Did you all learn a lot more about her in terms of her questioning style, her willingness to write concurring or dissenting opinions? Do you feel you know more about her as a justice now than you did a year ago, David?
I think no. Actually, we know a lot about how she will vote. I was a little surprised she wrote, from what I could tell, very little on the big cases. She just quietly voted and went along. So we know she's not, somebody who's hesitant or determined to be in the middle. But she strikes me as a very smart, capable person, and is a good writer. But the truth is, I actually thought Neil Gorsuch loves to write these sort of long sort of essays on various aspects of the Constitution. I find them quite interesting and readable. He doesn't, like in the Shurtleff case, the Christian flag, he wrote a separate concurrence on his whole view of the Establishment Clause, essentially where the court went wrong in the 70s and why we should do this and what. And so, in other words, he lays out the big picture. Brett Kavanaugh gives you the sort of practical, down to earth, is very focused on the key question. I always find his separate concurrences are really interesting and useful, because he's got his own take on it and he wants to explain why he came down this way or not the other. So far, Amy Barrett has not written a lot. She's not sort of joined into that. So the truth is, all I could say is, she proved to be a very conservative vote, but I don't feel like I know a lot more about her as a justice than I knew a year ago.
Yeah, I think David's exactly right. She seems to be a bit of an enigma. I was particularly surprised that she did not write a concurrence in Dobbs. She's the only woman in the majority in the case that overturned Roe versus Wade. And she just basically said ditto. I mean, there was nothing. I mean, what a moment to show. I mean, particularly since she made such a point during her confirmation hearings to say, I think for myself, I'm not anyone's mouthpiece. I'm not beholden to my religious faith. I'm not beholden to anybody else. I am my own person. But in one of the most consequential opinions, she doesn't write her view. She doesn't speak for herself about why she was in that majority. I found that really, really surprising.
Me too. The only phrase we know about her in the last year that people remember is her saying with Mitch McConnell, "We're not a bunch of partisan hacks."
Yeah.
That's not exactly the phrase you want to be known for.
But she does start her opinions with very clear summaries, which is appreciated, at least by those of us in the press gallery.
And she wrote a very sensible thing in one of these shadow docket cases. I think it was from Maine. I think it involved religious exemptions to a COVID employment mandate. And she said, and I think this really ought to be the case, that just as on the merits docket, the court is very wary of interceding, doesn't grant cert very often, nor should it intercede just because something arrives by way of emergency application. And it was only like 3 paragraphs long, but it actually set out a roadmap that the court has basically not followed, but should follow. Of just because it's emergency application doesn't mean it should necessarily address it.
So I saw in the news that her home was picketed last week, along with the homes of the other 5 justices who voted in the majority in Dobbs. Did any of you have reactions to this epidemic, if that's the right word, of residential picketing of justices' homes that we've seen in the last few weeks, or opinions about it that you're willing to share? Kim, you're paid to have opinions, so I can ask you.
The First Amendment is important. I'm not sure if you're trying to raise awareness and fight for a cause that's the most effective way. I mean, you're certainly not going to change the mind of the person whose home you target to picket, and you can draw a lot of fire from the other side. So I guess that's up to them. So long. One thing that I do think is interesting is that for some of these fights, particularly one involving the law in Maryland, where some of the justices live, I think that the statute that requires people to keep moving and not stop might have some First Amendment issues if challenged. And my question is, okay, well, if they challenge it and it goes to the Supreme Court, do they all recuse themselves? Like, how do you even settle that question
Right.
if it's challenged? I'm sure it might be. So I think that would be an interesting thing to watch.
Yeah, I mean, they did all participate in a case called Grace against the United States. I guess it was United States against Grace back in the 80s, which challenged a law that prohibited demonstrations in front of the Supreme Court.
Right.
And I think their decision was unanimous, saying that demonstrations couldn't be prohibited on the sidewalk in front of the Supreme Court, but nobody.
Yeah, but I think it's different if it's their house.
Yeah,
I don't know.
Maybe so. And of course, now we have a justice who's even newer than Justice Barrett. Ketanji Brown Jackson was just sworn in as the 104th Associate Justice after a confirmation hearing that was at least relatively calm compared to some of the others recently. And David, I believe you've covered the confirmation hearings of every single justice who's now on the bench. Do those hearings have any remaining non-theatrical value? Would it be better for us all if the nominees just stopped appearing as they didn't appear for most of this country's history?
Well, they were bad 30 years ago, and they've gone steadily downhill. It seems like each one gets a little worse, more partisan, more mean. You called this one calm. I thought part of it was just vile. Just Ted Cruz and Josh Hawley. Just how many times are they going to describe child pornography things to this judge who's tried to explain to them the difficulty and the basis for deciding these cases, whether the guy gets 5 years or 15 years, and then they would go back to reading and describing child pornography. So I just thought it was useless and vile and just sort of ugly. And so your question is, does it have any value? Very little as far as substantive. The only thing you come away with is you have the general public, for the one time only, gets an impression of this person. And I think Ketanji Brown Jackson was very impressive in sort of standing up and sort of working her way through this. I mean, she got a lot of mean, ugly questions and sort of kept at it and tried to explain. And so I come away thinking she comes across as not only a smart, good person, but, tough backbone and a formidable person. So, and I think at all of them, the public, the only advantage is you get a little of impression about who this person is, how they think, how they talk. But the actual questions, you don't really learn. You learn almost nothing about their views on the law because they don't want to say anything that's controversial, or they're do like Kavanaugh and Neil Gorsuch had to basically say, what about abortion in Roe? Well, it is, Senator, it's settled precedent, which of course means nothing. Yes, it's settled precedent, and so you don't really learn anything about their views, but you learn a little bit about them. And so I suppose it has some minor value, but it's really too bad that it's become, for both sides, it's just a partisan a food fight that most of the time.
Someone
Yeah,
will, sorry, go ahead.
No, I was just going to say it, and it has been for a while. It really has been since the Bork hearings. It's really unuseful. But I would say that part of what David is talking about, that certainly has increased since the Kavanaugh confirmation hearings. I mean, I agree with David. I think that Justice Jackson was the epitome of poise and grace and intellect during her hearings, but she didn't have, one of the things I did write for the Emancipator was pointing out the fact that she didn't have the space, she didn't have the ability, the privilege to have a meltdown the way that Brett Kavanaugh did during his confirmation hearings. The way it was completely different. She had to take it, or else she would have just confirmed all of the false narratives that the folks on the Republican side were laying on her. And that was uniquely unfair, but it's a unique experience that I know other women, in particular other women of color who are on this call, understand and have dealt with in the legal profession. So I think that highlighted that as well. But I think after the Kavanaugh hearings, they can never be useful again. I think that ship has sailed.
Well, someone will correct me if I'm wrong here, but of the 9 justices, I think only one was confirmed by a Senate controlled by the opposite party. That, of course, was Clarence Thomas. And in recent years, with the abolition of the filibuster for Supreme Court appointments, there's no question that whoever is nominated is going to get confirmed largely with the support of the president's party, unless there is a total meltdown. And we can debate, the Kavanaugh hearing and what that represented and who his audience was when he testified that second time. But the truth of the matter is that unless, there's every incentive for senators of either party to behave badly in questioning the nominee, because if you're the one who succeeds in causing that meltdown, well, you can bank that.
Yeah.
I agree with everything that's been said. I think one thing to keep in mind is what you define as useful in terms of the confirmation hearings. If the goal is to find out what the nominee thinks about particular issues, I agree that they're not particularly useful. I do see one other value in addition to learning about the nominee, and I feel like I learn a lot about the nominee watching the confirmation hearings as well, is that it is, tends to serve as a refresher for people who don't think about the Supreme Court that often, don't know that much about the Supreme Court, about how the court operates and what issues are likely to be coming before the court in the future. And so we heard about stare decisis, we heard about the Harvard and North Carolina affirmative action cases. But I agree with everything that everyone has said about the behavior of some of the senators, and question whether that is a sufficient purpose to continue to do them.
We've had several people in the Q&A box say, when are you going to talk about the leak? So let's talk about the leak. How did that affect the court? How did it affect your jobs, other than that you could write the story 2 months in advance of the decision? But what impact did it have on the institution and on your job? Anybody?
Well, in the short term, so the leak dropped, it was in the evening. I think it was on a Tuesday. And my husband and I were leaving dinner. We'd had dinner with some of his family members. And so the first way it affected us is I had to find a way for him not to crash the car. So his editors were calling him, my editor and podcast producer were texting me, and I just told him to you drive and I will read this Politico story. And that was the first thing that we did. We got home. I immediately went to my office, which is in the basement. He went to his, it's upstairs, and we didn't see each other for hours. So yeah, that was a very unusual moment. My husband, by the way, covers the court for Bloomberg News. But in terms of the bigger picture, I mean, it was surreal. It was shocking. I couldn't believe I had to get past, writing something and then doing an emergency podcast before I could really absorb just how wild that was. I mean, the Supreme Court, I would have never thought, even at its most dysfunctional, that the Supreme Court would leak an opinion, that anybody, a clerk, I mean, that would be political, career suicide, or certainly not a justice or anybody. I mean, it was just so wild to comprehend. But the immediate feeling that I got was that the institution was changed forever. And you could see that I mean, I just thought, how can the people within that building trust each other? How do you fix such a breach of protocol? What does that mean about how the people inside the building see the institution? And you could see after that when, Clarence Thomas, for example, was speaking openly about it, and how, now it feels like you have to look over your shoulder, and that there was a real level of distrust that I know some other justices like Sotomayor since has spoken and said, well, no, that could, we're still a family and we still can heal from that, and we can still come back. The court's reputation can come back, but I'm not sure it can exactly the same way. And that just leads to my earlier point, where I used to say all the time, the court is not a political institution the way that the other branches of government in Washington are. But after that leak, it certainly felt like it.
So you all can't sort of, wander the corridors, I guess, the way you used to be able to. But do you have any feelings about whether the court really has changed beyond this term, or whether it's going to revert to sort of standard trust and relaxed, maybe relaxed is the wrong word, normal feelings?
So the leak and the substance of the leak are intertwined. We're of course focused, and it's important, on the damage this breach of trust did. But there's also the fact that hard on the heels of 3 Trump appointees, a constitutional right in place for 50 years was eliminated over a very strong dissent from the 3 liberal justices. That also can't do anything good for the collegiality of the court. So there's both a process and a substance point here. And I think that Justice Thomas's remarks should be taken at face value. He said it was a kind of infidelity that the court that sat together for 11 years before the rapid turnovers we've seen since 2005 was a family. It is no longer a family. I think it may take some real time to heal from all that.
I thought it was interesting that it was Thomas who said that out loud, because he mostly won a lot this term, and you might have thought someone on the winning side would be a little more positive in outlook. I mean, maybe sugarcoat a little bit, but he didn't. I mean, in fact, as someone said earlier, it was Justice Sotomayor who came out and said, we're still a family, whatever. I am not sure what I think about what this means for the court, inside the court. I mean, we know that later this month, Barrett and Sotomayor are taking part in a joint program. I can't remember where now. So, you know, those sorts of things will continue. And I wanted to say earlier that it is true that on the days of the biggest arguments, like the abortion case, there was a certain seriousness, it was almost somber when the justices took the bench. Most of the other times, they came out from behind those curtains trading a joke or a smile, and that sort of continued. And I'm just not sure yet how that all plays out in terms of their relations with each other, leaving aside what all of this means for the court's reputation vis-a-vis the public.
And do we know anything about the investigation? Has the marshal been searching people's cell phones? Are there any quote persons of interest at this point? Have you gotten any feeling about how that's going? Looks like the answer is no. At least they're not leaking that. And someone asked me, are the law clerks still talking to each other, or are they afraid to do that? Do any of you have insight into that kind of a situation either? No. Well, if anyone in the audience is a close friend of a law clerk and wants to share anything in the chat, feel free.
You know, that crop of clerks, if not already, is largely gone from the court.
They're gone, yeah.
You know, they're moving on to their next thing, and a new crop of clerks is coming in, which is
Right.
interesting from the perspective of the investigation. If you know, if there's still work to be done there, and as you said, Art, I don't know what the status of the investigation is.
Yeah. Yeah, I mean, I wonder, for example, instead of sharing drafts electronically, as I assume they must have been doing during COVID, whether they'll start using couriers to circulate paper copies, each one of which has a secret little mark on it, so you can tell whose copy got leaked, if anything get leaked, which I understand is sometimes done in other parts of the government. So I guess we'll find out, or we won't find out. It spurs me to wonder, have any of you ever gotten a leak from the court? And if so, what did you do with it? I guess maybe you couldn't tell us if you had. So here's a question that sort of comes out of the Dobbs draft, but is more general too. We know that Justice Alito had circulated an opinion in early February, about 2 months after the argument in the Dobbs case. And yet the decision didn't come down until the end of June, 4.5 months later. It's hard to believe that the dissenters needed 4.5 months to write their dissent. And so why does the court wait till the end of the term to hand down not just Dobbs, but all of these big decisions, some of which were argued in the fall? Presumably majority opinions were circulated months ago. Is there some, do you think the court sees some value in holding all these things for the very end rather than spreading them out through April, May, and June? Or they just have, bad study habits like I do, and everything is only done when there's a deadline? Adam, is that your view?
Yeah, I think the basic idea is that the bigger the case, the more it's likely to, be reprinted in case books, and generations of law students are going to read them. Both sides will take as long as they can to explore every argument and respond to each other's footnotes and so on. It's also been suggested that on a really hot case like this, they'd rather not drop it in April and then have to live with each other for a couple more months. Their summer breaks are really a time to get away from each other and regroup after the kind of rough business we saw this year.
Yeah, and it's particularly with Dobbs, I was actually expecting that to be on the very last opinion day, just because of the protests and the fact that the security gates had gone back up around the court for that reason, so they can drop it and get out of town. I don't know the reason for particularly Dobbs it took that long. Some conjecture is that the Chief Justice was trying to use his power of persuasion to make his more limited take carry the day, and maybe he was taking time with his concurrence in the pursuit of that as well. You know, he only needed one other justice to join him, and he wasn't ultimately able to get it. So I could see that taking a long time. Also, when you have, I mean, that dissent in Dobbs was incredible in that it was signed by all 3 dissenters. It was not written by one and joined by the other 2. So I just, as between the 3 of them, they probably had a lot of drafts going among them as well, which probably did take some time. But yeah, all of us, I'm deadline driven, so I would assume I understand if the justices are too.
But that's, the leak was abnormal, right?
Yeah.
But the big decision on the last week of the last day of the term is normal.
Yeah.
And so there was nothing unusual about that. And it's always been the case that the big cases, there's a back and forth. You know, that was a very long, very good dissent. And then Alito has a chance to respond to it. I remember Rehnquist would sort of sometimes complain about at the end of the term as that he didn't have a chance to fully respond to some, you know, Scalia would occasionally take him on and say mean things. So they really, in May and June, are still going back and forth and responding. And as everybody said, it's a really big case. There's a real division. There's a matter of writing for history. I mean, so I thought there's nothing surprising with thinking they're going to take all the time until the end of June. I'm sure all of you had this, my editors say, oh, is this case going to come out in March or April? Should we be ready? And I said, well, you know, I don't want to say no, but probably the answer is no. It's probably going to be the last week in June. And that's just the nature of the job. I didn't think there's anything unusual about Dobbs in that sense.
You asked one thing in particular, though, about the fact that the majority draft circulated in February, and as far as we know, by early May, nothing else had circulated. And just on that point alone, I totally agree with what David said, but on that point alone, I think it's at least possible that Roberts had been working on a concurrence and perhaps sharing it with 1 or 2 justices, hoping maybe he could circulate something that would attract that 1 vote that he needed. And then it's also possible in that instance that the dissenters said, we're not going to circulate our draft dissent until we see whether Roberts succeeds in this. I mean, I think that's all possible, but I don't know that definitively.
Makes sense. Makes
Yeah.
sense.
Yeah. So, of course, the leak was an enormous breach of ethics, but there's been a lot of discussion about another kind of ethics at the court this term too. And attention has been especially focused on Ginny Thomas's political activity and then Justice Thomas's failure to recuse from the case in which former President Trump sought to block the House January 6th committee from getting certain White House records. And then we learned after that case that Ginny Thomas had actually communicated with the House Minority Leader saying that the January 6th committee subpoenas were improper and didn't serve any valid legislative purpose. Is anything likely to come of all this other than a bunch of, pardon me for making little of them, newspaper editorials, Kimberly?
It depends. It's really up to, in some limited way, the Chief Justice. It's up to the Judicial Conference. It's up to Congress to create rules that put teeth in the enforcement of ethics rules when it comes to the SCOTUS. I mean, the SCOTUS is, I know a lot of times people say, well, the SCOTUS isn't bound by the same ethics rules as other judges. They actually are. There's just no enforcement mechanism. There's nothing, the only enforcement mechanism is a justice makes a choice for himself or herself about whether to recuse from a particular case. And we have seen that Justice Thomas will not recuse from any case that his wife may have been involved in with, and this isn't the first time, right? This is the case involving January 6th was the most direct. But Ginny Thomas, for the last 20 years, has been involved with a lot of conservative groups who have either participated in funding challenges or their group submitted amicus briefs in cases, in everything from, immigration cases to Citizens United to the Obamacare. I mean, she's been involved in a lot of cases that have been before the court. So perhaps that's why not a lot of attention was paid, because she'd been doing it for so long. It wasn't until that January 6th has really crystallized it. But until there's teeth in the ethics rules that bound the justices, then nothing will change.
Does anyone else think anything might change? Is Congress going to set up an enforcement mechanism that would?
There was a whole commission. There was a whole executive branch commission about reforming the court.
Yeah.
That was done just because Biden kept getting asked the question on the campaign trail, and he didn't want to advocate anything and said, well, I'll set up a commission to look at it. And it was almost as if they were charged with not doing anything. Like that was their goal. So if nothing could come out of that, if they can't come to a conclusion, in fact, the majority of those on the commission essentially said, well, the only way for the court to reform is for those reforms to come from within the court. Like the court has to be the ones who advocate for this, and they have to take it upon themselves. Well, we've seen that's what they've been doing. And we've seen that what that means. It means there's no enforcement. So at that point, I think it was pretty clear in Washington that everyone would rather throw their hands up, even if they see the problem, than do anything about it.
One of the things I find interesting about the ethics issues is that, the justices generally don't explain themselves when it comes to recusals. And it seemed to me that the one exception to that is if a party asks a justice to step aside, that sometimes then that produces an opinion, like the opinion Justice Scalia wrote regarding his hunting trip with then Vice President Cheney. But that doesn't happen very often. I mean, the parties are reluctant to do that, I imagine. So we don't see it very often. But until you force justices to start explaining themselves on these topics, I don't think much will change.
Well, and the pot of gold at the end of this rainbow is having the justice recuse, right? I mean, that's the ultimate. And a lot of these there's like an 8-to-1 vote. Thomas casts the one vote. And so, okay, maybe he should have recused. That would be a good thing, but it wouldn't, in a sense, it wouldn't change anything. It would be just, he would be sort of acknowledging quietly that this is too close to my wife's involvement or business. But in other words, there's no, these are not likely to be, if it was a 5-4 vote and there was something really big, it really hung on Clarence Thomas's participation, the court was really evenly divided, then that's a big deal. But the hope is that he will recuse in a certain number of motions or whatever that touch on January 6th. And the answer is he probably won't, but even if he did, it wouldn't make any difference.
We've got about 15 minutes left, so let me focus us for at least a little while on what's coming up for next term. There are a bunch of cases that we already know are likely to be quite big. Affirmative action in college admissions is one, and the Voting Rights Act and whether it requires Alabama to have an additional majority district is another. But one that I think they just granted at the very end of the term, and many people I think don't really quite know what it's about, and maybe you could all talk about it a little, is Moore against Harper, which has to do with this independent state legislature theory. Amy, can you tell us what that theory is?
Sure. So this is a theory that has been around at least since 2000 in Bush versus Gore. Then Chief Justice William Rehnquist wrote about it in a concurring opinion that was joined, I believe, by Justice Scalia. And the idea is that the elections clause of the Constitution gives sole authority to regulate federal elections to state legislatures, which would mean that state courts cannot make changes to federal elections, elections for Congress, the presidency. For example, it was raised in one of the Pennsylvania cases that came up to the court in during the 2020 elections, when the Pennsylvania Supreme Court extended the deadline for counting ballots. And so this case has come to the Supreme Court arguing that the North Carolina Supreme Court changed the rules of the election, that only the state legislature has that authority to do so. And it is a theory that, if accepted by at least 5 justices, could have an enormous impact on the regulation of elections going forward.
Does anyone have any guesses where that's likely to go? Adam?
Well, we know, Art, that 4 justices in a variety of settings have already written sympathetically. 4 sitting justices have written sympathetically about this theory. And Amy is quite right that if you give state legislatures power to set election rules unmoored from their own state constitutions, they can just do whatever they want, and the state Supreme Court can't tell them, no, that violates the Constitution. That's a recipe for all kinds of mischief.
And what's really interesting, I find, about this case, and I know that there are different justices on the court, or are there? No, maybe it was before. Well, the last case, the Rucha case, where the court considered partisan gerrymandering, one reason that they came to that conclusion to say, hey, we don't even have jurisdiction to look at this. Like, this is not our problem. It's for state courts to handle that. You have another avenue. And so for not 3 years later, for them to turn around and say, oh, by the way, no, state courts can't, would be just a really remarkable thing. And as you know, we're here as journalists, and as a journalist whose job is to try to explain what the court is doing, that's one of the increasing number of areas where it would be really hard to explain some, the incongruity of what the court does, sort of very similar to this term, right? You have Dobbs on one hand that says, no, it's up to the states to decide whether or not to outlaw abortion. But then on the other hand, in the guns case out of New York, it said, no, the states can't. It's not up to states to regulate this thing. It's hard to really draw the sort of conclusion that it's to explain how you those two things jibe, because they don't. It will be, again, very difficult to explain the ideology, the worldview of this court that can hold both of those decisions at the same time. One thing that I have found just in general, though we're trying to search for a worldview of this court, is that it keeps rolling back to this idea of tradition and whether it's about stare decisis, whether it's about the separation of church and state, history and tradition, and what this nation has always done, and what is the that background. And so that makes me worry that means that for many people whose rights have only recently in our nation's history been recognized and protected in a very forceful way by the courts, that it can be in peril, or recent things that have been done to try to boost election participation, for example, that too can be something that the court looks sideways at in favor of a more, strict interpretation that the founders may have meant. I see that as a general direction of this conservative court. So in that sense, I am very concerned that it will be this idea. It's like, no, if that's what the Constitution said, then that's the way we have to do it. In this case, of course, in other cases, they can ignore parts of the Constitution, like the part about the militia and, the part about liberty. But it seems that's the only through line I can see about what this current makeup of this court is doing, in the way that they're choosing to take on these cases. I mean, I think a court just a few changes ago of a different makeup would not have granted cert on this issue. And the fact that they are granting cert now is something I think is concerning, if that makes sense.
Yeah, let me ask a follow-up question for my own elucidation. If this theory prevails, does that mean that state Supreme Courts can't review legislative actions for consistency with the federal Constitution, or just not with the state Constitution? Presumably, well, I say presumably, the Constitution didn't say to the state legislatures, you can
Yeah.
do whatever you want, even if it's inconsistent with this Constitution. And so would both state and federal courts still be able to review legislative actions with respect to federal constitutionality? Does anyone have a guess?
I don't, what you say makes sense, but the really wooden reading of the elections clause, which says the election rules subject to congressional supervision, to be sure, but the election rules shall be set by the state legislature, might even conceivably
Yeah.
oust the federal Constitution.
I mean, yeah, of course, the legislature can act in a way that is more restrictive or add additional things that's not in the Constitution to that extent that they speak.
You can imagine the state legislature saying the votes of X category of citizens will not be counted, violating the 14th Amendment. But I guess we'll have to read the briefs. I don't think anybody's going to stand up and say that would be okay. At least not yet, right? Well, we'll see. So another case I wanted to ask about is 303 Creative against Elenis the court had a number of opportunities to take cases where people said, for religious reasons, I'm not going to provide my services to same-sex couples. For example, they had the Masterpiece Cake Shop. They punted on it. There was the florist who sought cert at least twice, maybe 3 times, that they denied it. I wonder if they were just waiting, if the conservatives were just waiting for a better vehicle, and maybe they found it. So in this case, the plaintiff is a website designer who wants to branch out her business to create wedding websites, but not websites for same-sex weddings, which she has a religious objection to. And the lower court said, you're subject to the state equal accommodation laws. You've got to create websites for same-sex weddings or for no weddings, and they granted cert. Have the conservatives finally got the case that they wanted here? Do you think there's any real doubt how that one's going to come out, David?
Yes and no. They've got the case they wanted, and there's no doubt she will win 6-3. And the only question is how they write that. Is it a matter of pure free speech, or is it one of these like the praying coach? It's a mixture of free speech and the free exercise of religion. There's a sort of religious element to it. So I think it's very easy for the conservative court to say, all she's asking for is, in a sense, an exemption, a speech exemption from a state law. And I think it's very clear she's going to win. And the question will be, how much damage does that principle do down the road if you create exemptions to ordinary state civil rights laws? Will it be narrow and rare, or is it a bigger problem? But I'm interested in what some of the others say, but I think she will surely win 6-3.
In the earlier court case, the argument from the defenders of the anti-discrimination law is that, well, if you can carve out an exemption from an anti-discrimination law when it applies to LGBT people, what about race? Why is that any different? And of course, the answer on the other side has just been, well, race is different. But it'll be interesting to see how that plays out in both the argument and the decision, because obviously they say it's different, so that makes it different. But there's what the principal basis for that difference is isn't quite clear to me.
It's sort of the same theory that abortion is different. Why is it different? Because abortion is different. There's another characteristic this website case has, which seems to be getting more common at the court, which it's not clear that there's an actual controversy. The designer has not actually gone into this business, has not faced any kind of punishment or sanction or discipline. And just as in the EPA case, where the court ruled on a regulation that doesn't exist, I think the court will very likely here rule on a completely abstract kind of advisory opinion basis.
Which is another issue entirely. Sort of one thing I think we are seeing is the expansion of the court's own power in a way that it didn't operate before.
So maybe I've got time to squeeze in one more case just briefly, but one that caught my attention is called National Pork Producers Council against Ross. And I wonder if it really has a tremendous potential impact. California has banned the sale of pork unless the sow from which the pork came was housed in a cage that has a lot of space, apparently much more space than most pork corrals, whatever they're called, have. And the pork producers say this is going to have a dreadful impact on production of pork nationwide. It's going to raise the price enormously because you can't tell if the pork in your hamburger came from one sow or another. So every pork producer in the country is going to have to change his operation because Californians buy a lot of pork. And it violates the Dormant Commerce Clause, they say. And yet it seems to me states like California have often, in areas like auto admissions, made rules for what you can do to sell things in their state. And people have had to make changes nationwide because you want to be able to sell your cars in California. And that it would be quite revolutionary to say that California can't do this. But I wonder, does anyone have a sense in our minute and a half left whether that argument is likely to have traction? Well,
someone must think it has merit, Art, because they kicked
They
it around
granted
for a
it.
lot of time and finally granted it.
yeah,
I thought, as you said, that they're asking for something that's a little bit novel or new to say that, California's saying you don't have to sell your pork in California, but if you do, it's got to meet these standards. Clarence Thomas and some of the conservatives say we don't like Dormant Commerce Clause arguments, so you would think that's but in the end, they granted it. So I have to think that there's four of them, maybe five of them, inclined to sort of change the law a little bit on the Commerce Clause about whether they're arguing that one state is dictating this rules and procedure for, in this case, pigs for the entire country, and California should be able to do that. And my impression is there's probably 5 or 6 anti-California votes on the court. So I think it's possible that the pork producers could win.
I guess we'll see. So my clock says 1:30. Thank you very much to all of the panelists. Thank you for everyone for attending. Christina, I'll bounce it back to you if you have a word to close.